Now it's the 18th of May 2022. I've just made a video 2045H, and this is 45I. HI. I think I gave the right date in the one immediately preceding to this, the 18th of May 2022. Sometimes it's possible to make a small error that could destroy a video, but I just have to move on. Now, what I'm dealing with here is the recent developments, which I am very, very excited about, and many others, with the European Court of Justice. Now, I won't read you down the judgment completely, but the questions were put: what's the story with these circulars and plans and guidelines and all that in the European Union when they weren't assessed? Okay. And it was the Grand Chamber delivered this judgment, and that's the highest form of the European Court of Justice. That's the top. And the opinion was given, the name of the people are there, their names is, so the people were A and others, and T. Swerts, and W.J. Ingalls, and L.N.I.J.S. Advocate, and Organisation for Energy, something. So look, a big long, it's foreign languages, it's Belgian languages. But there's two languages in Belgium, as I understand. I'm not quite sure, it doesn't matter. So the judgment is: this request for preliminary ruling concerns the interpretation of Article 2A and Article 3.2a of Directive 201/42/EC of the European Council and Parliament of the 27th of June 2001. I'm shouting now because I'm looking down, please forgive me. The request has been made in proceedings between A and others, and Gertie Wiggle, Streichel, Biggle, Angbar, oh my God almighty, you want to try and study this, regional town official of the Flanders Department of Land Planning. So the people that made the circular for the setback distances and all that for wind farms were in Flanders, right? That was a part of Belgium, no problem there. Now, the deal here with international law, environmental impact assessment, and transboundary, where there's a project going across international boundaries, and the Espoo Convention, we don't have to go into that, and it goes down in Article 5 to European law, and Recital 4 of the directive, SEA directive. Environmental assessment is an important tool for integrating environmental considerations into the preparation and adoption of certain plans and programs which are likely to have significant effects on the environment in the member state, because it ensures such effects of implementation of plan or programs are taken into account during the preparation before their adoption. And it goes on then to explain the directive and all that. And plans and programs shall mean plans and programs including those co-financed by the European Community, which are subject to the preparation or adoption by an authority at national, regional or local level, and which are prepared by an authority for adoption through legislative procedure by the Parliament. That's the Planning and Development Act, the planning application, and which are required by legislative, regulatory or administrative provisions. And an environmental assessment shall mean the preparation of an environmental report, the carrying out of consultations, the taking into account of the environmental report and the result of the consultations in decision making, and provisions for information on the decision in accordance with Article 4 and 9. And it goes on then to say, you know, that directive allows you to take a judicial review against the wind farm, and that's what people are doing. There's no need for me to go in there. Now, I'm going now, it says here about Belgium law, and I'm not going to read all that, you can read that yourself. But what it deals with, first of all, is the status of these regulations. And essentially, if they're to be taken into account with the planning authority, then they have status. So, for example, if the Irish Wind Energy Guidelines of 2006 was brought in by the Legion of Mary, or the Salvation Army, or the Society for Irish Astronomical Society, or something else, they'd have no effect. They have to have sufficient public authority to be taken into account by the planners. And of course, if it's issued by the Flanders Regional Authority or the Irish government, that is beyond doubt. I think you can understand that's beyond doubt. That's beyond doubt. So, but it has to be like that. So the guidelines or the pamphlet or whatever it is setting out the directions for the noise and shadow flicker, they have to be done by somebody with sufficient authority. That was not questioned in this case because it's obvious, and that was not questioned in Ireland or other cases either. It's the government does it. So you don't need me to state that anymore on 5 minutes. And the next thing is about what the disputes are. And what the disputes are was, to cut to the chase, is what happens where guidelines are used to as part of the environmental impact assessment. That's the EIA Directive 211 and 214. It amends it. And these guidelines or plans or pamphlets or circulars have never been put through the SCA process under what I'm after reading to you there, Article 3.2. That was the question. And now I'm going to read the judgment. I'm getting on fairly well for time. I'm trying to shout and my throat's a bit dry, but this is for a specific audience. And I don't mind if people read it. It's all about corruption. This should have been done long ago. If the EU was doing its job like they did in Derrybrine in Galway with the wind farm there, which killed 50,000 fish, we wouldn't have to do that. But unfortunately, it's down to the ordinary Joe Soap to follow this up. Now, in a judicial review on European law on the environment, there's a protective costs order, which means that assuming everything goes well, you'd only pay the costs of your own legal team. And if you're a lay litigant, as I have done 3 times, you only pay your own costs. It worked out for me, roughly with everything, cost, travel and all, each time about €500 when you pay the fees and the court stamps and all that. But if you met a judge or some particular opponent who wanted to try and make you pay costs, you'd have to fight your case, and you can appeal to the Supreme Court on that. But that's just to let you know there is a protective cost order. But for groups that's facing a big wind farm, as there are in many places, cost might not be the problem. It's really getting the case right and winning. And some of them do win. There was one down in Derrynagad in Longford because they didn't specify the type of wind farm and all that. Now, so this is the judgment on 7 minutes now, and it's only 3 pieces, and I'm going to read it. I'll read it and explain it. On those grounds, the Court of Grand Chamber, that's the highest court, hereby rules. Article 2.3, Article 2A of Directive 2001/42/EC of the European Parliament and Council on the assessment of the effects of certain plans and programmes on the environment must be interpreted as meaning that the concept of plans and programmes covers an order or circular adopted by the government of a federal entity of a member state, both of which contain various provisions concerning the installation and operation of wind farms. So this case, it'd be persuasive if it was about quarries, but this is about wind farms. So it's sitting for you there. I'll read that again now. The question was, what's the story when it wasn't assessed? What's the story with the guidelines or the circular? And I'll read it again. Article 2A of the SCA Directive, right, on the assessment of the effects of certain plans and programs on the environment must be interpreted as meaning that the concept of plans or programs covers an order or circular, which this was, and which the Irish renewable energy guidelines, wind energy guidelines, are also, adopted by the government or a federated entity of a member state, both which contain various provisions concerning the installation and operation of wind farms. Must be interpreted as meaning the concept of plans and programs covers that. So that if they make a plan or program and they make a circular or a guideline under that plan or program, if they say we're going to put in wind farms, we're going to have all this renewable energy, and that do a guideline, it must be interpreted as being part of the concept of a plan or program. That's the first. Number two, Article 3.2, this is my favourite one, of the directive, SEA directive, must be interpreted as meaning that an order or circular, both of which contain various provisions concerning the installation and operation of wind turbines, including measures on shadow flicker safety, noise level standards, constitute plans and programs and must be subject to an environmental assessment in accordance with the provision. And they weren't. They weren't. Must be subject to it. And they weren't. Haha. Now, number three, where it appears that an environmental assessment within the meaning of the SEA directive should have been carried out prior to the adoption of the order or circular on the basis of which a consent, that's a planning permission, which is contested before the National Court, that's when you go in your judicial review, was granted for the installation and operation of wind turbines, with the result that those instruments and that consent do not comply with EU law. Do not comply with EU law. That court may maintain the effects of those instruments. That court may maintain the effects of these instruments and that consent only if the national law permits it to do so in the proceedings before it, and if the annulment of the consent would be likely to have significant implications for electricity supply of the whole member state concerned, and only for a period of time strictly necessary to remedy the illegality. It is for the referring court, if necessary, to carry out the assessment in the case of the main proceedings. What that means is, what if somebody takes a case here in Ireland to shut down all wind farms that are existing now, built in contravention of this? The court has to shut them down. But if it can be shown, which I believe it can't, that it would result in a blackout for now, or whatever emergency it might be, or it was the dead of winter or in a storm, they can allow the wind farms to continue, but only for as long as it takes to remedy the situation. And I read that to mean they'd have to replace the wind farms with something else, either nuclear power, coal-fired power stations, gas-fired power stations, or whatever, or put in some other thing, or do something else. It just lets them off that they can't be made shut them down. However, if it was just one local wind farm, like Rara wind farm here, or the one being built in Tard, it'd be very hard for the other party, now even though the courts would be on the other party's side, to say, this is going to cause a breakdown of power here. But the big thing is, one, all new planning permissions must be annulled if the guidelines are used in the EIA, which they have to be. That's the first thing. Secondly, the concept of plans and programs. Secondly, Article 3.2 does apply. It constitutes plan or programs. So the guidelines or the circular is part of plans or programs. It's plans or programs. It's put in there as part of a plan or program. So it is a plan or program. And three, where it has been already carried out before the adoption of an order or circular on the basis of which the consent was contested, that's existing wind farms before the National Court, which is contested before the National Court was granted for the installation and operation of wind farms, with the result that those instruments and that consent do not comply with EU law, the court may maintain the effects of those instruments. They may keep them in place, and that consent only if the national law permits it. If it's allowed by law, which in Ireland everything's allowed, it permits it to do so in the proceedings before it, and if the annulment of that consent would be likely to have significant implications for the electricity supply, but only for the period strictly necessary to get it remedied, to get a replacement supply. Now, if in Ireland, you go in on that, the first thing the opposition will hit you with, and by golly will they fight it. So I believe you just go through the High Court as a first step, go through the motions. The Supreme Court, when you have to appeal, and you need to be able to appeal and go in there, and you need the wherewithal to be able to appeal. When you go into the Supreme Court, the Supreme Court might make this ruling, they might strike it down, or they might refer to the European Court of Justice, but the result can only be the same. They'd have to show that Ireland was different, that the wind farms in Ireland was different, and they can't. They're the same everywhere. So they're caught very, very badly on that. But what the opposition will say is, these wind energy guidelines came out in 2006. They came out in 2006. You had 8 weeks to take a judicial review against them under the SCA directive, under the law of Ireland, and under the Rule 84 of the rules of the Superior Courts. You didn't do it. You're too late. You're out of time. This is the first thing they'll throw at you, among other things. It's possible the Irish court, especially the High Court, depending on the judge, could agree with them and say no. So that's why you have to be prepared to go to the Supreme Court, and you have to be prepared to go to the European Court of Justice. Now, on the issue of time, and it is very strict in Ireland, on the issue of time, a habeas corpus, if it's your freedom, if you're in prison and you're doing a 5-year sentence, and after 6 months you discover something wasn't right, that the witness told lies, or the warrant was wrong, or the police was corrupt, or whatever, you never run out of time to challenge that court decision. You can do it in 5 years, 10 years, or whatever, if it's your personal liberty. Generally speaking, on contracts and things like that, and other things, they don't, there's a time limit. If you lose your case on a right of way to land, and everything's appealed, and 5 years later there's a new decision that would have changed that, you can't reverse it because everyone has acted on it. That's a kind of a point of law, and that's all right. But this is a bit more like the habeas corpus, or the personal liberty. Here we have illegal what do you call them, guidelines in place for about 16 years now, I think, since 2006, and all this has been built. But this case came out, this case only confirmed it in 2019, 2020. You see, so you couldn't really challenge it then in 2006. But that will be what's argued. Now that might wash a little bit in the lower court, in the High Court. Doubtful if it'll wash in the Supreme Court. But if it's referred, as you're entitled to have it referred, and if you lose in the Supreme Court, you have to go to the European Court of Justice, and you need barristers. But it's very simple. If it goes there, the European Court of Justice has to strike down the Supreme Court and the High Court here, and write back to them and say, you have to do this, whether you like it or whether you don't. That's basically the case. The out of time provision would mean that European law would be ignored for the next 100 years. That, in my opinion, won't wash. Now, the other bit of good news, folks, on 18 is, and I'll be coming back to this maybe tomorrow a bit, there has been a case since that in the Netherlands. And the Netherlands local court said there's no point going anywhere. There's the European Court of Justice. It's done and dusted. It's done and dusted. I'll just pause here for a moment. Now, folks, I just got it there. New wind farms in Holland, in the Netherlands, frustrated by court rulings, right? Now, on the 30th of June 2021, Administrative Jurisdiction Division of the Council of State in Holland issued a judgment in a case regarding the provincial executive permit issuance for the expansion of a wind park close to Denzel, all funny words, according to the administrative jurisdiction. Anyway, it goes on there. You'll get it if you want. There, it's there. If you just Google it, you'll find it there. Essentially, the Dutch court said the European Court ruling applies, and that has effectively ended wind farm extension and development in Holland until they get this straightened out. Okay. Now remember, the Irish government has been promising for years that they'll bring in new guidelines. issued a distance of 507 metres as opposed to 500 setback distances. They didn't do it, and I know why, because they cannot bring in new guidelines when all of this has been built. It was the government's responsibility to make sure everything was properly assessed. They didn't do it. They put them up in defiance of all this law. I and others were crying about this and shouting at them, and they would not listen. They would not listen. So now they have the situation, if they bring in new guidelines, and we'll say this, put the setback distance at a kilometre from a wind turbine, well, what happens ones like here where they're only half a kilometre? Would that not be grounds for us to sue and have them closed down? And they're just trying to do the best they can with it, and they're stuck badly. You can't issue guidelines retrospectively. That cannot be done. They'd have to have expertise, and there'll be some fight in the courts if they bring in the normal setback distance of 500 metres. When the 2006 ones were brought out, wind turbines were only small. They're only 70, 80 metres. Now they're 150. So there'll be crack with that. So they're just keeping their head down and they're bullying on. So I've dealt with that now to you, and I hope that groups will consider this and have a good think about it. Let me say, I know going through the courts, it's very difficult, and they throw everything at you. They are past masters at muddying the waters and all that. And but the only way, and I remember years ago down in Cavan Town, there was a planning application for a housing estate granted by the council. We wanted this, that and the other. We were local people. I was down there at the time, and people wanted that, and they granted. And I got the people to appeal to Burplanola, and I got a call from an official, now long retired, in Cavan County Council, telling me that you do not appeal to Burplanola in Cavan. That's not done. And I told him to get the hell out of my way. That's what happened. He was a nice man enough. I told him to get the hell out of my way. You do not appeal. You do not do that. That was his attitude. And I went in with 7 others to Cavan County Council, and two planners, 2 planning authority people, admitted to me they never heard of the EIA directive or any European law at all. They never heard of it. So this law has to be wrestled out of the Irish state, out of the judges and out of all. But that court case on wind turbines is the nicest and best piece of a decision I've ever seen. It's custom built for attacking this menace. They'll try and get around it. All I can tell you is have a good read at it. It's there. Any reasonable good barrister who's used to this type of law will be able to cite it. All you need, going to plead it on your statement of grounds, one simple ground, that the wind energy guidelines are not assessed, and that the environmental impact assessment that was prepared and it was used to grant the permission is illegal under European Court Case 2419. And that's it, and then the fun will start. They will argue you're out of time, but that'll work maybe at local courts, but it will not work when they go into the Grand Chamber of the European Court of Justice. The quicker we get this done, the quicker we get in and get it done, and somebody does it with a new wind farm, then there'll be some hope for the likes of me to tackle my one here, because the court said these ones have to come down as well. Hopefully that's something to look forward to in due course. And it's something for those who invest in wind farms to realise they could see their wind turbines shut down over this case. There is no way around this case. They'll do everything to get around it, but there is no way. So they want to turn Ireland into a hedgehog. It'll affect everyone eventually. We have to try and stop it. Folks, that's the longest video, too long. Sorry about it. Give me a thumbs up and give me a thumbs down. I know you can't hear maybe everything I see, and I might do a third video on it just to clarify any few points, and if I made mistakes I'll get them clarified in that. Thank you very much, and we'll see you back for something else. Bye.